In 2017, a family was jarred awake by the FBI smashing down their door and deploying a flashbang. It turns out that the FBI had the wrong house. The family turned around and attempted to sue the government, but the courts ruled against the family, saying that you can't sue the government for bad judgment. Now the case is going to the Supreme Court. Hello everyone, and welcome back to the channel. When anyone else messes up in their job in a really big way, one can reasonably assume at least some level of accountability. Unfortunately, that's not necessarily a given when it comes to law enforcement, and is almost a joke when it comes to the federal government. And today's story is a perfect example of that. And the Supreme Court has just agreed to hear this case, which could have huge implications on how federal and even local law enforcement conduct raids. But before I get into the details of the case and the events leading up to it, this video is brought to you by Blackout Coffee Company. Blackout is a Florida-based coffee roaster with deep roots in supporting the Second Amendment, soldiers overseas, and channels like mine. They even have dedicated partner roasts where some of the proceeds go to some of your favorite gun rights groups directly, like GOA and FPC. So to help support the channel, your rights, and get a cup of coffee, tea, or hot chocolate that you can be proud of, go to blackoutcoffee.com/libertydoll, and you can use code libertydoll for a one-time 20% discount. As I said in the intro, one October morning in Atlanta in 2017, Hilliard Toy Clyett, his partner Katrina Martin, and Martin's 7-year-old son were sleeping peacefully in the pre-dawn hours when suddenly an FBI SWAT team in full tactical gear busted down their door. Agents tossed in a flashbang and, fearing for their lives and thinking that they were being robbed, Clyett pushed Martin into the bedroom closet where he got his legally owned shotgun. But just as he was about to grab it, the FBI burst into the room, threw him to the ground, and handcuffed him. Agents began interrogating him and Martin at gunpoint, while others went to the son's room and for some reason held him at gunpoint too. Though, 7-year-olds can be terrifying. Minutes later, when Clyett told the agents his address, they realized that they had the wrong house. Not only was it the wrong house number, in fact, it wasn't even the right street. After the FBI realized that their current address didn't match the one on the warrant, they left, found the right house, executed the warrant on a gangbanger, and made an arrest. A day later, an agent came back to apologize, handed them a business card, and offered to cover any damages. And then the family tried and was turned down. Unfortunately, according to the courts, the government has no obligation to cover any damages, lost wages, or injuries in this case, including the years of therapy the little boy needed after he became paranoid about suddenly dying or being hunted by government agents. The FBI, meanwhile, blamed the mistake on their GPS. Honestly, with the man being a gun owner and about to reach for a shotgun, the family is lucky that none of them got shot. There have been roughly a dozen cases of wrong house raids on legal gun owners that I can think of off the top of my head in the last decade or so, like the recent case of Doug Harless. I covered that on my channel just a few weeks ago, and he unfortunately did not come out of it alive. AmmoLand has a list of about half a dozen cases where a gun owner shot at police during a surprise wrong house raid, lived, and was found not guilty of any wrongdoing because of law enforcement's mess up. But when it comes to damages, that's a little different, because the courts, at least down in the 11th Circuit, say that you can't sue the government over an agent's or agency's bad judgment. See, in 1974, after 2 wrong home raids, Congress amended the Federal Tort Claims Act to specify that claims can be made against the government in various situations, such as false arrest and abuse of process. Clyett, Martin, and their lawyers say that their case should fall under this act. But the Atlanta-based 11th U.S. Circuit Court of Appeals said the Federal Tort Claims Act doesn't apply if the disputed action by the law enforcement officer involved an element of judgment, even if the officer abused his discretion. The court also said that the Supremacy Clause, the section of the Constitution that makes the federal government the supreme law of the land, blocks the suit because the mistakes made were reasonable in the rapidly changing and dangerous situation of executing a high-risk warrant at night. The problem, according to the courts, is that the agents did come and pick out the house ahead of time, but because both homes were split-level houses with a stoop on a corner lot with a tree, it's somehow not the FBI's fault that they went to the wrong address. The similarities in the homes apparently make this a reasonable, non-suable mistake, which is an interesting take, that it's reasonable that no one checked that they were at the right place before busting someone's door down. And not to mention, the Supremacy Clause doesn't really apply here. The point of the Supremacy Clause is to say that when a federal law and state law are in conflict, the federal law wins. It's not a clause to give the FBI immunity from not double-checking an address and raiding the wrong house. The Justice Department asked the Supreme Court to stay out of the case, saying that the lower court had made the right decision, of course because it means not paying up, and said that because there was no lower court split, it shouldn't reach appeal. But you see, other circuits have ruled in favor of the families in similar cases, have not put forth this same weird argument about the Supremacy Clause, and so the Supreme Court agreed to hear it this spring. We are expected to have a decision by the summer. The family is being represented by the Institute for Justice, a nonprofit libertarian law firm that has brought cases to the Supreme Court before, and the appeal was backed up by a group of 7 members of Congress, including good old Rand Paul and Thomas Massie. The others are surprisingly all Republican, with one Democrat, who is Ron Wyden of Oregon. Given the ridiculousness of the case and prior rulings in other circuits, I can't imagine SCOTUS ruling against this family, but crazier things have happened, so we will see. I think it definitely would change some policies around no-knock raids going forward if they do rule in favor of the family, or at least requiring people to double-check an address. All right, folks, that is it for this video. I will definitely be following this case when it actually gets heard and we get a decision on it. In the meantime, you know the drill for all of the algorithm things. Please do them. And as always, thanks for tuning in. Stay safe out there and happy shooting.